just when I thought this case couldn't get any more bizarre. The state is seeking third-degree murder based on child abuse. Is the court going to give this any serious contention or consideration? Because if so, we have a lot of talking to do. We can start with Mr. Manti dumped all of this on us sometime around 7:30 this morning. There was an email, oh, by the way, we've changed our lesser included request from aggravated assault to third-degree murder based on child abuse, and put 10 or 15 cases that obviously he has spent hours, if not days, if not in fact maybe more than a year plotting for this moment when he can spring it on us and the court. Somewhere we wondered why the state would put this vague allegation in the information that Trayvon Martin was 17. No other charge of child abuse, no evidence of anything other than this statement that Trayvon Martin was a minor, 17 years old. First of all, I moved to strike it as surplusage because it's not related to any element of the offense for which George Zimmerman is charged, nor related to any conceivable lesser included offense. So I guess what's happened now since the time that the state filed its information in April, that they've been lying in wait, collecting all this loosely connected child abuse case law where 2-year-olds have been shot by someone who was reckless with a gun, or some child exposed to horrible deprivation or abuse resulting in death. Just so at this moment, on the day of closing arguments, we would have to deal with it. Well, I can say it's certainly consistent with the way this case has proceeded since April, but it's certainly just as disingenuous as well. This is outrageous. It's outrageous that the state would seek to do this at this time in this case. Now, if the court wants to recess for several hours so we can research and review these cases, draft a memo of law, we can do that, and we certainly are entitled to the opportunity to respond in a meaningful way. But it's just hard for me to imagine that the court could take this seriously. Certainly the court wasn't provided with the case law either, nor given any hint that this is where this was going to go.
Well, in all due respect to that statement, the court hasn't been provided a lot of things that have been requested to have hearings that the court has had up until late in the evening, until the last minute, or I requested of it. So that in and of itself is not an argument, and I don't want to go there. So let's go on to the argument about this instruction.
I'm not prepared to make an argument. This was just emailed to me, buried in the set of instructions that the state's obviously been working on for months and months and months, just to spring it on everyone at the last minute. Mr. Manti has this fully formed, organized argument based upon all this case law that I guarantee you he didn't come up with between yesterday when they wanted aggravated assault and this morning when they now want third-degree murder based on child abuse. Really? Ms. Corey's sitting right there apparently approving of this.
That's not proper argument.
It's not fair to me, it's not fair to Mr. Zimmerman or Mr. O'Mara or the court for this to happen like this right now. I need time to sort this out if the court is going to give any consideration to this remarkable suggestion by the state that somehow third-degree murder based upon an 827, Chapter 827 and Chapter 39 violation of the child abuse statutes could somehow, when Trayvon Martin is shot straddling George Zimmerman, pummeling him, that somehow George Zimmerman was engaged in child abuse?
The Supreme Court's jury instructions that are online and in the rules of criminal procedure books indicates that the offense charge of second-degree murder, a Category 1, is manslaughter. A Category 2 is third-degree felony murder, vehicular homicide. Non-homicide lessers would be an attempt, culpable negligence, aggravated battery, aggravated assault, battery, and assault. These are part of the jury instructions that have been known to this court since I've been on the bench.
Your Honor, did the court ever for a second think...
I'm not finished speaking.
I'm sorry, I
please.
apologize.
Thank you. The possibility of a Category 2 is known to counsel at the beginning of the trial.
Your Honor, in the same way we would expect vehicular homicide be offered?
But the evidence doesn't support that, and the state's argument is, at first yesterday when they provided the court with the possible lessers, and one of them was aggravated assault, I didn't have any information available to me that led me to believe that that would be a charge that would be given, because the facts did not support an aggravated assault lesser included offense.
Yes.
Their argument today is that the facts support a third-degree felony murder with the underlying enumerated felony being child abuse. That is permissible under the statute. If you need I'm not going to give you hours. You have, I don't know how many lawyers you have working with you on this case. Well, you have 4 in the courtroom, and I know there's a room downstairs full of people who...
Ms. Truitt's a lawyer, and Mr. O'Mara's a lawyer. That's who we have as lawyers on this case. Everyone else is a volunteer, an intern who has really done remarkable work, but we can't rely on non-lawyers to do the kind of work that's necessary right now. Judge, this was a trick. Doesn't the court realize this was a trick by the state?
My intention right now is to get through the rest of the jury instructions, because if we have any arguments about the others, I would like to get them resolved. We will come back to this one.